Reasonable notice, or pay in lieu of reasonable notice, is what an employee is entitled to have who has no written employment contract, or where there's a problem with the employment contract or the termination clause in the contract. Reasonable notice is what a court would give to an employee who lost their job without cause. Reasonable notice ranges from a couple weeks to 24 months in British Columbia, and that's 24 months of all the elements of pay that the employee would have earned if they had been allowed to keep working for the notice period. So the entitlement to reasonable notice is determined based on 4 factors: the employee's age, the length of time that they worked with the employer, the character of the job that they did, and the length of time it's going to take them to find similar employment. So a younger, more junior employee with a shorter employment is going to be entitled to notice at the lower end of the range, whereas an older employee who's approaching retirement, who is in a senior position, who's been with the employer for a long time, they're going to be entitled to reasonable notice at the top end of the range, even 24 months. The employee's bonuses, stock options, benefits can all be included in the calculation of what are they entitled to have during the reasonable notice period. So when an employment lawyer meets with an employee who has been dismissed, they're going to look into the case law, taking into consideration those 4 factors: the age, the length of service, the character of the employment, the reemployability, and find similar cases that they can connect to their client's case to say, my client is entitled to this range of notice. Maybe it's 18 to 24 months, maybe it's 6 to 8 months. They'll usually determine a range unless there's a case that's really exactly the same, and then they might try to pin it on that. We do find that online severance calculators are not helpful in this exercise. It really does require a careful look into the case law. An experienced employment lawyer will have a good instinct about how much notice the client is entitled to have without having to look into the case law. But it is always the best practice to look at the case law and make that determination.